Good day, Crime Talk aficionados. We have a great show for you today. First, some chilling new details emerge in the Idaho murder case. Karen Reed has got to be questioning some of her life choices right about now. Sean P. Diddy Do It Combs says, I was too drunk to commit any crimes. A conviction in the Colorado rock throwing murder. What do I keep saying about men who want to hang out with kindergarten age children? Let me give you another example. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. We have a great show for you. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Before we get to the docket, let me remind you to go to crimetalksearch.com. When you go there, you can sign up for a background subscription service today. And when you have that background subscription service, you can do as many background searches as you desire. You go, you sign up, you get the report, it'll be emailed to you, and you can even get subsequent updates as well. And in that report, you're going to get information about the person that you're searching, emails, addresses that they have, phone numbers, social media presence. Do they have a criminal history? Are they married? Are they divorced? Do they have liens, judgments against them? Criminal history. And oh, by the way, are they on one of those sex offender registries? Yes, everything that you want to know about a person before you make a time commitment into that person. And maybe that person or his family is just not giving you the warm, fuzzy feelings. You know, your little spidey senses are starting to tingle. Go to crimetalksearch.com and sign up today. You're going to be happy that you did. All right, ladies and gentlemen, we have a great show for you. Let's get to it. Now, we have brought you a lot of Bryan Kohberger stuff on throughout the week. Friday, the court came out with new orders in that case. 3 to be exact. The orders for defendant's motion in limine regarding vague and undisclosed expert testimony. The order on the state's motion in limine regarding the text messages and 911 call, probably the most significant as it relates to trial issues. And then, of course, the order on the defense motion to strike the death penalty because Bryan Kohberger has autism. The judge shot that order down based upon Supreme Court case law, basically saying, hey, this guy, although he has autism spectrum disorder level 1, he can function just fine in life. He is not special in the sense that he has some sort of mental inability or mental capacity as the previous Supreme Court case law has defined, because in those previous Supreme Court case law, there's several fundamental principles. We don't impose the death penalty on people that have a mental disability. They used to call that the R word. And now, obviously, no one under the age of 18. Judge says, the guy was in a PhD program. Give me a break. He's very functioning. He knows what's going on. Denied. Now, the other big one, and I went over this word for word on Friday's show. So if you haven't seen it, I urge you to go there and watch it. All kinds of good details in there. But let's give you the brief summary today and then a little bit of comment about why is everybody picking on these roommates? All right. So like I said, chilling new details emerged in the Idaho murder case, a night that maybe could have changed everything. So in the new court order, the judge overseeing the Bryan Kohberger case has unveiled new details about the final hours of the 4 University of Idaho students who were brutally stabbed to death in their off-campus home. Now, drawing from the testimony and text messages of the 2 surviving roommates, the revelations paint a vivid picture of a night filled with ordinary decisions that nearly altered the course of a tragedy. On November 13th, 2022, Kaylee Gonzalez, Madison Mogan, Zana, some people tell me I'm mispronouncing it wrong, Zana Kernodle, Ethan Chapin were together in their home, unaware of what was going to unfold. About 2 a.m., the 4 were gathered in Kaylee's bedroom chatting and winding down after a night out. And Miss Kernodle was still out with her boyfriend, Ethan, at the time. In a moment that now feels fateful, the roommates debated heading back out for a late night snack at a food truck. One survivor, DM, even texted an Uber driver at 2:10 a.m. to check and see if they were available. Ultimately, they decided to stay in and just go to bed. A choice that sealed their fate in that house when a masked intruder struck just 2 hours later. Now, the court order issued by Judge Hippler details the events that followed. Around 4 a.m., DM was startled by strange noises and crying from the bathroom. Investigating, she caught a chilling glimpse of a figure dressed in black wearing a ski mask passing by her bedroom door. Panicked, she texted all 4 of her roommates, but only BF, the other surviving roommate, replied. And the two exchanged frantic messages, shaken by the lack of response from their friends and the sinister presence. The two exchanged frantic text messages, shaken by the lack of response from their friends and the sinister presence DM had witnessed. By 4:26 a.m., DM rushed to join BF in her downstairs bedroom for safety, and in her haste, she unknowingly passed Zaina's lifeless body on the floor, mistaking her for being drunk. The two survivors locked themselves in BF's room, spending the next 8 hours desperately trying to contact their roommates, unaware of what had taken place just feet from them. It wasn't until almost noon that they made a 911 call, which later became a pivotal key piece of evidence in this case. Now, the details emerged as part of the court order granting prosecutors' request to admit selected text exchanges, testimony about the survivors' conversations, and the 911 call into evidence. Kohberger's defense team fought quite hard to exclude that evidence, arguing that it was inadmissible, but the judge ruled that portions, if not almost all of the portions, constituted hearsay, and they wanted them to be barred. Anyway, Kohberger obviously is accused of murdering Miss Gonsalves, Miss Mogan, Miss Coronel, and Mr. Chapin, is facing a trial that begins on August 11th of this year there in Ada County after he successfully had a change of venue motion granted. That Mr. Kohberger's DNA was on a knife sheath, his cell phone location data, and surveillance footage of cars matching his vehicle link him to the crime. His defense, however, claims that he was just simply driving alone that night and denies any involvement. If convicted, obviously, Mr. Kohberger can ultimately face the ultimate punishment of the death penalty. So I want to talk a little bit about this tragedy. All right. I mean, this was a cold-blooded murder. 4 people are obviously dead. And we're going to give Bryan Kohberger the presumption of innocence. But as I've said, as a criminal defense attorney that has practiced for some 30 years doing almost exclusively criminal defense, that as a defense attorney, you have to look at your bad facts. And you can always usually tell what some of the bad facts are for the defense on what they're trying to keep out. Okay. Obviously here, the defense was really trying to keep out that DNA evidence. And we can go into, it's not blood DNA evidence, it's touch DNA evidence. Ladies and gentlemen, it's DNA evidence. Okay. Your DNA wasn't on that knife sheath. Okay. Your DNA wasn't on that knife sheath button. Mine wasn't on there. Just coincidentally, by happenstance, Bryan Kohberger's knife sheath happened to be there. Now, for the people that say, oh my God, it must have been planted, I say that is a wonderful theory. How do you prove it? Show me who planted the evidence. Okay. And I'm not saying he's guilty. I'm just saying you have to look at it. And if you're looking at this case from a defense perspective, that'd be great to say, obviously, it was planted by the one-armed man. But you have to be able to prove it. It doesn't matter what you think, what you believe. It only matters what you can prove. And what evidence do you have that somebody stole, allegedly, Bryan Kohberger's knife? Maybe it was never actually delivered to his house. It was intercepted via the mailing from Amazon, right? How do you prove that? There's no proof of that. But there's proof that he ordered the knife, the sheath, and a sharpener. We have information that he tried to get another one as well after the murders. Certainly goes to consciousness of guilt, does it not? Or, I just happened to lost my knife one night when I was out walking in the woods looking at the stars. Let's get for real, ladies and gentlemen. A lot of people also want to bash on these roommates. You know what? Who's probably bashing these roommates hard enough is themselves. All right. First of all, they too could have been killed by the intruder that was in their home. Additionally, you don't think they probably second guess those decisions that they made that night, thinking I should have called somebody sooner? Absolutely. I'm sure they did. But we also know that they had been drinking. They were scared. They didn't know. This house has a reputation for a party house, people coming and going. They probably thought, she didn't think much of it other than, well, that was weird and creepy, right? Here's this guy. Okay, now I'm freaked out. Nobody else is answering. Okay. Or do you think, okay, I'm a college kid. Do I call the police, at this very moment? It could be some weird dude in the house. I don't know. They'll explain it on the witness stand, and if it's not to the satisfaction of the jury, that's it. But for these people that are out there, I've actually seen people say that, well, these roommates must have had some involvement of it. You may not like their kind of looking back hindsight. Well, I would never have done this under this circumstance. I would have called the police immediately. I would have investigated. Really? One thing I've learned of doing criminal defense for such a long time is that weird stuff happens. Weird stuff happens in very stressful moments. I've had cases where I'm like, that couldn't have happened. No way. And then we find out stuff that corroborates it, that that's just the way it went down, like it or not. Okay. But I've actually even seen people say that these girls were somehow involved. You know, that is probably one of the most disgusting things that somebody could say. And unless you have proof that is admissible in a court of law, you all should apologize to those young ladies for even thinking that. It's weird. I get it. But those were their friends. Do you think that they wouldn't have done something to help their friends out if they truly had known what had taken place? No. I find that hard to believe that they would not have done that. So everyone needs to stop bashing on these roommates. They're going to get subject to cross-examination. I'm sure Miss Taylor can take an easy approach with them. You didn't do this. You didn't do this. My guess, it depends on how they come across in the stand, if they're very credible or not. But push comes to shove. Maybe Miss Taylor will accuse these girls of being involved in some way, and you know the real killer or something along those lines. She can do that because she's got immunity in court. But guess what? She's still got to have some inkling of evidence to back it up. She must have a good faith basis for it to ask that question. I haven't seen anything to indicate that there is anything that would link these roommates to the death of their 4 friends. So unless you got some real evidence, not speculation, not conjecture, not some tinfoil hat craziness, then back it up with proof. And I'll be more than happy to listen to your proof. Maybe I'm wrong. I just haven't seen anything yet. Next, the Karen Reed case. Guess what? Can you believe it? The United States Supreme Court denied Karen Reed's motion, writ of certiorari to the United States Supreme Court. Shocking. The only one who is surprised by this will be Karen Reed, I'm sure. Because, I mean, the reality of it is the trial court screwed up and not questioning the jury further. The prosecutor screwed up and the defense attorney screwed up. I'm sure the defense attorneys were doing that pro bono / gratis for Karen Reed because they're the ones that should have asked, can we see if they've reached any decisions? But they were trying to get that mistrial because they thought that was their hope, their chance to hopefully get this case thrown out if they had to do it again. Remember, the defense was the one that kept asking for the mistrial. So anyway, as Karen Reed stands trial for the second time on charges that she murdered her boyfriend, the United States Supreme Court, well, that's right, dealt her team a blow when it announced it would not hear her appeal. So Monday morning, the United States Supreme Court issued a list of orders, including cases the justices determined they would not hear. Karen Reed's case was one of them, and she was denied a hearing. Reed now has no other appellate options with any of the courts at this time. Obviously, if she's convicted, she can appeal any conviction. We'll give her the presumption of innocence. We'll see how trial goes. But as the second week of trial began, the prosecution called a guy by the name of Ian Whiffen. He's a digital expert, and he showed jurors cell phone data he said indicates that Mr. O'Keefe did not go inside the home of Boston cops as alleged by the defense. And in fact, he did not go inside the home of the Boston cop, as the defense team had suggested in the first trial after he exited Miss Reed's car the night before he was found dead. Now, prosecutors called Ian Whiffen. Like I said, he was a digital intelligence expert with the company called Cellebrite. Cellebrite is the company that's been making all the information, the software to download cell phones forever. Now you have Gray Key, but Cellebrite is still kind of the company. Anyway, he examined O'Keefe's cell phone location data the night before he was found dead. The most accurate location data starts about 12:20 a.m. when O'Keefe's opened the navigation app Waze on his phone. He told jurors it is accurate within 5 feet. And based on that data, Whiffen said O'Keefe's phone did not stop near the driveway of 34th Fairview Road, the house where O'Keefe was found. Whiffen said the phone appeared close to the area near the flagpole on the opposite side of the lawn, where O'Keefe's body was later found. He added that the accuracy of the location data decreased by 12:25 a.m. after Waze was closed on O'Keefe's phone. Now, Whiffen also analyzed the phone's battery temperature and Apple's data health on the night of January 29th to 2022, and he said the battery temperature dropped from around 80 degrees when it reached 34 Fairview to an eventual low of 37 degrees hours later, indicating that it never went back inside. You know what that means, ladies and gentlemen? The data says he didn't go inside. He never made it inside. Anyway, the health data from O'Keefe's phone showed that he climbed 3 flights of stairs while he appeared to be in the car. Whiffen said the flight climbing events appears to be the result of the car traveling uphill. Anyway, together, Whiffen said the information indicated to a reasonable degree of certainty, in his expert opinion, that the phone remained in the area near the flagpole from around 12:24 a.m. to when O'Keefe was found. The defense team briefly began cross-examination before the judge dismissed the jury early today. Now, Whiffen also testified about internet search history data on the phone of O'Keefe's friend, Jennifer McCabe. McCabe was a central figure in Reed's first trial, and she is the sister-in-law of Bryan Albert, one of the men the defense team in Reed's first trial argued killed Mr. O'Keefe. And on the morning of O'Keefe's death, McCabe allegedly looked up how long it would take someone to die in the cold. McCabe said Reed asked her to make the search after they found O'Keefe lying in the snow. Reed's defense team argued during the first trial that the search was made hours earlier. However, Mr. Whiffen, a third party, doesn't work for a state lab, doesn't work for the defense, no dog in this fight, just telling you what the data shows, gave jurors a detailed timeline of McCabe's search history starting around 2:30 a.m. on January 29th of 2022, and he said a search was entered for how long TIDIEINCIKD, how long to die in cold. Obviously some typos there. And he said that took place at 6:23 a.m., but it did not load. Now, last week, one of the last witnesses was physician pathologist Gary Fowler. He testified about the chemistry process used to test Reed's blood for alcohol on January 29th in 2022, the morning O'Keefe was found dead. The test showed a blood alcohol content of 93 milligrams per deciliter, according to the good doctor, and that converts to a 0.093 blood alcohol content by volume, right? Remember, the over the limit is 0.080. And during questioning by Reed's defense attorney, Fowler said that the type of alcohol test done in a medical setting for the purpose of diagnosing health issues is different than the type of test used in forensic and relied upon in the court of law. Fowler said the serum testing is just as accurate as whole blood testing. The defense obviously argues that Ms. Reed's anemia may have also influenced the blood result. Listen, yes, you have the breathalyzer tests that people can use. You know, it's accurate. You have a blood draw that a phlebotomist can take and they can test the blood. And then you have the stuff that they do in the hospital. My experience, the stuff in the hospital is much more accurate. Now, remember, Miss Reed's blood, remember she dropped him off early morning hours, blood test somewhat 7-8 hours later. Now, I know she's going to say that she drank, but when, maybe when she got home, that's it, right? That's the defense, right? Wasn't drunk, didn't kill him. But at some point when she was tested, hours and hours later after allegedly dropping off, 0.093, she was drunk, ladies and gentlemen, when that blood was drawn. As I noted earlier, the judge adjourned the jury early to resolve an issue of 2 defense team witnesses. The judge dismissed the jury about 12:55 today to deal with issues regarding accident reconstruction experts that the defense team plans to call as witnesses. And the judge found that the defense team previously had failed to give the prosecution materials related to the witnesses during the discovery process. So like I said, ladies and gentlemen, I think Miss Reed is definitely questioning some of her life choices at this point. I know she loves Mr. Jackson, all right? But things aren't coming together like they did the first time. I've been in that first trial where you're like, things are going better. I can't believe they agreed with this. The prosecution wasn't ready. They didn't know it was coming the first time. And what have I said? Second trials never fare better for the defense because the prosecution has fixed their case. Do you think Mr. Brennan so far has fixed their case for the prosecution? I told you he was good. Let me know. Let me know in the comments. What do you think? I mean, we'll see how things go. We'll never know what a jury will do. I'm just telling you, the prosecution is putting on a much better case this time around. Next, Sean P. Diddy Do It Combs said I couldn't have done it because I was too drunk. Oh my gosh, Sean P. Diddy Do It Combs. Why haven't I thought of that defense? Ladies and gentlemen of the jury, my client was too drunk to commit the crime. He was high on drugs. Oh, that's right. It's not a defense. If that were the case, everybody would have no charges against them if they did something wrong. I'm sorry, I was too drunk, Judge. Didn't know. Yeah, voluntary intoxication is not a defense. So anyway, old P. Diddy's defense team involves coming up with a mental capacity defense, saying that he didn't have the mental capacity to commit the crimes when he was essentially too wasted. He apparently has even got a doctor to testify to this. But the feds, the prosecutors, think it's totally irrelevant point, and I think the prosecutors are right in this particular case. So prosecutors filed their objection to that line of testimony, and the documents say that Diddy wanted to have the doctor, who's a Columbia professor, testify that he had a mental condition bearing on his issues of guilt. What does that mean? Well, the detail of the alleged condition is redacted throughout the document, but there are some clues, including a bit amount of Sean's alleged drinking and drugging. Prosecutors say a legal precedent requires the defense to give proper notice before offering any evidence to the effects of drugs and alcohol on a defendant's memory or cognitive function. That's like if you were roofied, ladies and gentlemen, you didn't know it, but that would be involuntary intoxication, not voluntary intoxication. One other clue is the prosecutors describing the doctor's potential testimony as evidence of the defendant's inability to control his behavior. What's interesting in the federal indictment that accuses Sean P. Diddy Do It Combs of drugging his victims into compliance during these alleged freak-offs, but now it's a question of whether old Sean Diddy Combs himself, was he in a haze during the alleged crimes? Even if he was, prosecutors say the doctor's opinion on whether Sean Combs was lucid is completely irrelevant. And in the filings, they point out that the doctor never personally examined old Sean Combs, and his testimony was based upon his experience of others. Prosecutors also want to block the testimony of a forensic video expert regarding the Cassie hotel beating video, which the judge has already ruled that is coming into evidence. The judge hasn't ruled on these particular motions yet, but guess what? The trial is coming up next week, and man, do I wish that the federal courts allowed televised recording of the trial. This would be huge. Here's the defense for old Sean P. Diddy Do It Combs. 1, nothing inappropriate ever happened. 2, if it did happen, it was completely consensual. Those are your two defenses. And you probably better pick one horse to ride. That's the general list. Nothing inappropriate happened. And if something happened, it was consensual. You went to this party, you came here, you drank, you got a little imbibed, and next thing you know, you're in the back bedrooms doing whatever they were doing. Apparently putting on lots of baby oil, I'm assuming. But the point is, that's the defense. All this other nonsense. Oh, I was too drunk to know what was going on. No, you say, Sean Diddy Combs kept saying, yeah, we had some wild parties, man. And it was, I'm not going to admit, it was going to get a little blue in there. It was getting crazy, right? But it was all consensual. That's all he's got to say. And it's a question of fact then as to the people that are going to come in and say, yeah, I went to his party. Nobody forced me to go to the party. I drank. Nobody forced me to drink anything. And I had sex. Well, that was involuntary. You were forced to do that. And you say, well, you weren't because you stayed for like 3 days, or you stuck around, you called him, you texted him, those type of things. So we'll see how it goes. It's going to be an interesting one. We'll try to bring you as much information we can once that trial starts. Next, verdict in the Colorado rock throwing case. A Colorado man is going to be sentenced to life in prison behind bars after he was convicted of murdering a young woman by throwing a rock at her car, smashing her windshield. So Joseph Koenig was only 19 years old when charged first-degree murder, attempted murder, third-degree assault, and attempted third-degree assault in connection with the 2023 death of Alexa Bartel. Now, Bartel was killed on April 19th of 2023 when a large landscaping-sized rock crashed through her windshield as she was driving in Jefferson County going under an overpass. Anyway, Koenig's sentencing is now scheduled for June 3rd. Approximately a week after Bartel's death, police arrested Koenig as well as Zachary Quack and Nicholas Carroll Chick. Both Quack and Carroll Chick pled guilty, accepting deals with prosecutors that required them to testify against Koenig at his trial. Quack described what happened that day, saying that they had gathered the landscaping rocks from a median area along the road, and at some point, Quack said that Carroll Chick and Koenig began throwing rocks at stationary cars, describing Koenig as throwing with his dominant left hand shot put style. Anyway, Quack and Carroll face potential sentences of up to 32 and 72 years respectively when they too are sentenced. Now, I'm sorry, 72 years for an 18, 19-year-old kid. I don't know. I probably would go into trial or recommend going to trial on that. But hey, you never know. It's ultimately the client's decision. But 72 years, crime of violence, you got to serve 75% of that in Colorado. Ouch. Ouch. That's a long time. Going to be an old man by the time he gets out. At least he'd gone to trial. Maybe he'd have some appellate issues. I don't know. It just seems like a long shot. And 32 years, I get it. It's murder. The death of Miss Bartel is an absolute tragedy. Just goes to show you being young and dumb can ultimately change your life for the worse. Make smart decisions, ladies and gentlemen. Next, let's upset all the teachers. Now, I get in trouble all the time. And, you know, like I said, I love my children, right? Stepkids, great. Love them, right? But I don't want to hang out with anybody else's kids. You know, not going to be like, hey, can I hang out with your kids and spend lots of time with your, little toddlers? Not going to do that. Okay. And some people are going to say, oh, Scott, it's another teacher case. You're lumping teachers into the one big category. No, I'm not. I'm not saying that all male teachers working around young children have proclivities towards children. I'm not saying that. I'm just saying a lot of the people that get arrested as teachers have proclivities towards children. As I've said it before, think about it. They go where the children are. They go for what they're interested in. Not lumping all the teachers, so don't give me the, oh, my husband has been a teacher for 45 years and he never once did anything wrong. I'm glad he didn't. Good on you. Okay. I'm just telling you, if you've noticed a pattern here, it seems like don't get me wrong. We got a lot of female teachers having sex with junior high and high school age boys. And we got a lot of male teachers doing here. So anyway, let's get to it. Anyway, Texas kindergartner teacher was arrested for allegedly soliciting minors online during a week-long sting investigation. Now, the kindergartner teacher at the Snyder Elementary in Conroe Independent School District was arrested Tuesday on charges of online solicitation of a minor. And it comes from the school as well as jail records. Please meet Bryan Schultz, who's entitled to the presumption of innocence. Maybe he just loves kids. Anyway, he taught kindergartner at the Schneider Elementary since August of 2021 and was taken into custody in an arrest unrelated to the elementary school. The principal confirmed in a statement to the parents. Obviously, you got to give the obligatory statement saying that the teacher's been arrested. He's in jail. And, we're going to let everybody know that upon learning of this arrest, the school immediately initiated the necessary personnel process to end his employment in the district immediately. The school administration is personally contacting parents and guardians of students in Schultz's classroom to inform them of the situation. The principal said that they are committed to student safety. And I want to assure you that the Snyder Elementary and Conroe Independent School Districts are committed to providing a safe learning environment for your children. She also added that the alleged actions of this individual do not reflect the professionalism and care exhibited by our Snyder Stallion staff and those who provide education to their students, a quality education. Mr. Schultz is accused and faces a second-degree felony charge of online solicitation of a minor. There you go, ladies and gentlemen. All right, next on the docket, this day in legal history. Now, because we're always bringing you as much information as we can, we're going to bring you what took place yesterday, April 27th. That was April 27th, 1861, when President Abraham Lincoln suspended habeas corpus in Maryland and parts of the Midwest to counter draft riots and secession threats during the Civil War, despite a federal judiciary ruling against it in the matter of ex parte Merryman. So on May 28th, 1861, the Chief Justice Roger Taney challenged Lincoln's action, arguing only Congress could suspend the writ of habeas corpus as per Article 1, Section 9 of the Constitution. Taney's ruling came in the case of John Merryman, who was arrested without a warrant and detained at Fort McHenry. Taney issued a writ of habeas corpus, but the military, under Lincoln's orders, ignored it. Taney acknowledged his inability to enforce the risk due to the military resistance and sent his opinion, President Lincoln. Now, Lincoln, who had previously criticized Taney's Dred Scott decision, defended his actions on July 4th, 1861 in his address to Congress, arguing that suspending habeas corpus was necessary to preserve the Union, questioning whether all laws should fail to uphold one. He maintained that the Constitution's silence on who could suspend the writ allowed executive actions in time of emergencies. Now, Congress later did authorize Lincoln's suspension of habeas corpus in March of 1863 for the war's duration. But it goes to show you, the question is, has that ultimate power? Executive is supposed to enforce the laws, right? But there's a national war going on, a civil war, 1861, right? Getting ready to start. Suspended habeas corpus. They say no, only Congress could do it. The courts say, yeah, only Congress can do it. But that's the thing about the courts. You and what army are going to enforce it? It's always been problematic for the courts. Anyway, let's talk about April 28th. All right. Today, April 28th, 1866, the Civil Rights Act of 1866 enforcement starts, granting citizenship to freed slaves, obviously a cornerstone of the Reconstruction era and the laws accompanying it. On April 28th, 1918, the Espionage Act's prosecutions peak, with socialist Eugene Debs indicted, testing wartime free speech limits. And then on April 28th, 1970, President Nixon authorizes U.S. troops deployment in Cambodia, prompting legal challenges to executive war powers, right? Ultimately into the War Powers Act. Then on this date in 1976, the United States Supreme Court hears Greggs v. Georgia, later reinstating the death penalty. Obviously, pivotal ruling there. And then on April 28th, 1994, Aldrich Ames, a former CIA official, pled guilty to passing U.S. secrets to the USSR during the Cold War. Ames further confessed that he continued spying for Russia after the collapse of the Soviet Union. And then in 2015, the United States Supreme Court hears Obergefell versus Hodges argument, later legalizing same-sex marriage nationwide. Obviously, a civil rights landmark case. Lots of important Supreme Court decisions right about this time. And then finally today, our dumb criminal of the day. An 88-year-old woman is accused of fleeing the scene after plowing her car into a mobility scooter of a 77-year-old victim, tossing the woman from the electric vehicle and hospitalizing her with injuries. Police say that Carolyn Segrist was driving at a Sam's Club parking lot in Clearwater, Florida at 8:30 a.m. just yesterday when the crash occurred. Now, Segrist, cops allege, struck Laverne Hampton's mobility scooter with the front of her Buick Envision. Hampton was thrown from the scooter and was obviously taken to the hospital. Now, Segrist allegedly did not stop at the scene of the crash to render aid or exchange information. Big no-no. Anyway, 4 hours after the incident, police arrested her for leaving the scene of a crash involving serious injury, a felony. Ms. Segrist was booked into the county jail and scheduled for an initial court appearance this morning. Now, Ms. Segrist lives about 4 miles from the Sam's Club in a condominium she purchased with her husband back in the late 80s. In 2023, though, it started. It's gateway crime. She pled guilty to careless driving that resulted in the crash. She was fined $166 for her conduct. Anyway, Miss Segrist, you are a dumb criminal of the day. Wouldn't have been that big a deal had you just pulled over, giving aid and taking your lumps. And well, guess what? They're probably going to take your license at 88. I hope I still have a license when I'm 88, but most 88-year-olds probably shouldn't. Anyway, Miss Segrist, you are a dumb criminal today for not stopping. All right, ladies and gentlemen, that's all we have for you today. Hope you enjoyed the show. Go and check out Friday's show if you want all the details from the court's ruling is in regards to the text messages and the 911 call. Anyway, thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.